Take one.
Hey, y'all. It's Jack. Just keep it rolling. That's perfect.
I'm Ashley Wilcott, Josh Shipper, Jack Rice, JASH.
This is the real us, and it's really practicing lawyers talking about the stuff that makes us happy, satisfied lawyers because we really like the law.
I want to tell you both. Here's what I like about this is I can say what I think. I don't have to rein it in.
This is our lives. We have been up close and personal in some of the most impossible circumstances you could ever imagine.
Here, Darrell Brooks, if I were on the bench, I would want to jump over the bench and strangle him. Because it's so frustrating. It's like, stop talking.
If you were on the bench, it would be over by now because at least in Georgia, our judges do not have apparently the same constraints that they do in Wisconsin. I clerked for a judge. I've worked in front of hundreds of judges.
But is it a regional or some sort of jurisdictional question, or is it
temperament?
It's a temperament wiring question of the judge. Maybe what we have here, and I think we do partially, is we have a really nice person.
Yes.
I think this judge is incredibly nice.
And she's reasonable, and she's trying to be reasonable with an unreasonable person.
I think she's obviously a very nice, wonderful person. I think she got marching orders from all the other judges and everybody else knowing what she was going into, which is a super high-profile case watched by the nation with an individual who's going to pursue this sovereign citizen stuff, and she was given marching orders. You're going to provide this kind of trial because it will withstand the abuse of appeals for the next 40 years because he's going to file 10,000 appeals.
Why would she react in the way that she has? Because rather than coming out and simply saying, here is my ruling, she comes out and explains long-term.
Yeah.
What we know,
that's exactly
but
why.
If you don't
She's
do that,
reasonable.
actually, that's what holds up. If you come out and explain your reasoning, now you're stuck with it.
Yeah.
If you just say, the answer is X, and then you shut up,
Yeah.
what happens is you can come
sustained,
back,
overruled. Next.
You can
Sustained, overruled. That would be me. Next.
100%.
Hearsay sustained.
100%
Hearsay
disagree.
overruled.
If I'm the judge in that case, I'm prepped to give him the perfect trial that gives him all of the opportunities, but have already foreclosed all the known attacks that sovereign citizens and other highly litigious appellate people, and that's precisely why when she read him the Riot Act today, when he was interrupting, speaking over, not allowing a record to be created, being disingenuous and rude, she was methodical.
She was excellent. Excellent.
And
Everything on the record.
But you don't think that was different, though? That's different than what we've seen sometimes when it almost appears that what she's doing is reacting to him. Because I think that was purposeful, intentional.
Planned.
This is planned. Whereas a lot of what I'm seeing from her is he does something outrageous.
Yeah.
And then she tries to stop him and explain all of the reasons why his outrageous behavior is inappropriate, which she doesn't need to do.
Because I think that encourages him. Well, let me shift though. I want to pivot because let's also be transparent. And you said something that made me think of this too, Jack.
What did I say?
I said, I think I like being the judge because I do like controlling the room. I'm good at that. And I'm good at seeing what everybody is doing and everybody's rights and honoring all of that. But you said, oh no, I control the room. I'm the defense attorney. There are a lot of defense attorneys who are just as bad as annoying as
worse.
Right? And because you are doing that, you are going to be distracting and disrespectful. Some judges, the worst person in the courtroom is one of the attorneys because they're that same way.
And that can be part of, colloquially, the game if you are a lawyer who's going for that kind of affect and presentation to a jury. Man, it can work. Because remember, criminal defense lawyers, I ain't there to make friends. I'm there to make 12 people get in a fight and not agree. That's how you win cases. It's not about bringing everybody together, kumbaya, 12 people, let's all agree. No,
just takes
I want
one.
you couple people go back there and fight with them people.
I'm a Parkland shooter.
Yes.
I want one of you to be able to stand up and say, I don't care what any of you think. I've listened to what you've had to say, and I've decided you're all wrong and I'm right, and
How
I'm
could
not
they do
moving.
that? Talk about the defense in the Parkland school shooter, Nicholas Cruz, because that's what they did. We know from jurors coming out. One person said, no, I don't care what you say to me. It's not the death penalty.
The question is whether they identified that juror early and specifically targeted, cleaving because you've got 12 people. If you notice specific reactions from one of them, you can target a juror as a litigator. Because if you know that you're connecting really well with those jurors, you can drive that wedge by making the arguments that you believe strategically are going to affect that juror.
And the way you're going to do that in a case like this is
I'm
that
fascinated.
is that when you're having a conversation with the jury, sometimes what you're doing is you're working your way through that jury. There are some juries you're not going to get. You're going to lose them, and you can tell.
Right.
And so you know that what's going to happen is that you're actually going to be looking at her. She's juror 14, and her last name is Hansen. And in your head, you're saying, Ms. Hansen, we need to talk about what's going on here. This matters to you. And so I'm thinking about who she is, what I learned during jury selection.
Right.
And as I am making arguments, I might actually tweak those arguments when during jury selection, she might have talked about she's taking care of her mother who's in a nursing home. I might actually start thinking, how do I weave nursing home into an argument so when I say it, she's going to go, oh God, I know what that feels.
And it's not just supplicating, it's also picking a fight. Because if I know that juror
Right.
number 2
Right.
during I'm law and order, or whatever their
Right.
issue is,
Right.
if I know he's easy to tickle, I love tickling a juror. All you got to do is get the juror tickled, and then they're going to get into
Poke.
boom.
No,
Boom.
you're right. And I think to that
You
point
raise
in the
kids,
Parkland,
they know how to press buttons like anybody's
and
business.
as my mom said, it's because I installed them in my children.
And
So
then-
of course they know
Yes.
how to push our buttons.
They are
because-
natural
How you
Right?
feeling about that?
Yeah,
it's right.
natural operators.
So
Yeah, who's running that courtroom?
right,
Right,
who is-
exactly.
oh yeah,
Not
me.
so much.
Oh yeah, they may let me think so every
Come
once
on.
in a while, Jack. So in the Parkland school shooter, I'm fascinated by all this. So we know all of the jurors were death qualified, meaning they had already been questioned to say, yes, I could theoretically impose the death penalty. That's a theoretical till they have to do it. That's a separate discussion. But you do know so much for the juror questionnaires. Could either of you, by knowing what happened by watching, can either of you conclude that you believe the attorneys identified that one and did, what did you call it, cleaver?
Cleave them out. And
Cleave
it's
them
basically
out?
just
Well,
cleaving them
that's a better word
out.
than cleaver.
Well, yeah, but it's that idea of like when you're herding sheep, you've got these sheep and you want a couple of them to
Right.
get cleaved out because they got to go get shorn or
Do you
so
think
send in
that
the dogs.
happened?
Yeah.
Or was, now the defense, I thought was that good. They were that good.
Oh, I
they
think the
did
defense-
stop before
But
high school at
the
Nicholas Cruz.
problem is that this is a cumulative process. So in other words, with jury selection, you may not get that much information. So when I'm picking a jury, sometimes all I get is they're married, this is their age, this is the age of their
This is what they do
significant
for a
other,
living.
this is what they do for a living, this is how many kids they have, and that's maybe all I get. Or I might get what their job was.
Right.
Well, that's not enough.
Right.
I mean, this is the whole idea that when you're picking a jury, you'll say, what do middle-aged men believe? You're like, everything. What do young women believe? Everything.
And
Right.
jury selection changes from jurisdiction to jurisdiction,
Totally.
from court to court, and from state to state. There are states where you don't get voir dire the way that you do in most places. The
Or
judge,
voir dire.
or
It's
voir
interesting.
dire,
It
or
depends on the part of the
however you
name.
want to
I'm just
pronounce
saying
it.
that for viewers
Yeah,
because
no,
it's
it's
true.
very
It's
real.
different. But you're still not answering the question. What do you think happened in Nicholas Cruz? Hearing a juror come out and saying there was one person who would not.
I think it's certainly possible, if not likely, that there was an identification or attempted identification by the defense during the workup of the case because you're spending that much time in the same
I
room.
think so too.
Well, with that much time that they spent, we had a very smart lead counsel.
Oh,
And some of the work she did, her closing was, I believe, stellar.
Yeah.
And I think it was purposeful and intentional, and she played it perfectly.
and what people aren't talking about is if there had been a conviction, the real masterstroke out of that defense was they gutted the state's presentation because the state was expecting to come back on rebuttal with all this awesome stuff, and they robbed him. I'm talking arm robbed him in court, said, never mind, you ain't talking about any of this.
But
Yeah,
you
we're
know
done
what?
here.
It was
But-
brilliant.
It was brilliant, but I'm also going to argue if you're a good litigator, if you're a good trial attorney,
Oh, you're gonna
you
fight it.
know no, you have to think ahead and think, what if they don't present it? Because I do believe some of that you should be able to theoretically look at it and say, what if? Because I'll give you an example. I had defense attorneys come to a hearing in which I was representing a state agency because they wanted to learn free discovery, everything about potential criminal charges.
Fishing
right?
expedition, yeah.
Smart.
And I saw that. So you know what I did? I said, fine. I went and got a certified copy of the bond conditions, which accomplished what my client wanted and got that into evidence. And that was it. And they were furious. Like, where are all your witnesses? And I thought, now you two are defense attorneys. You should know that I'm going to consider doing something where you don't get to hear 18 witnesses, right? Like, don't you think theoretically the state should have thought, wait a minute, what if they don't present that? We can't, you don't assume the other side.
Oh,
the
they
defendants
do all the
wouldn't-
time.
But you shouldn't. It's a defendant. They have the burden. You have the burden. You're the prosecutor.
If they
So
did
why are
do
you going to
things they
assume
shouldn't,
that
they
Josh
wouldn't
is
be
going to
very good
present
state
A through
employees.
Z?
That's it.
Sorry, that was mean to state
I'm
employees.
just, that really bothers
That's
me
how it
because
works. That's part of the game. The word that works in my head is nimble. You have to always be ready for what comes or what doesn't come. And if it doesn't, you have to be able to figure out where you go next.
Because really, if that had happened and the state was prevented from bringing up some of this stuff, they could have then used that as their own silver lining, their own nugget on appeal later on, and talk about how expectations weren't met and how this case deviated from the way that every other death penalty case ever, because most death penalty cases are granular in the detail, and that got taken away from the state. There's an angle there. I'm not saying it's a good one, but you always have a recovery and you always move forward no matter how bad the beat was.
I think it was ego. I think the thought was, this is the worst of the worst. To me, if you look at it, I think as a lot of people might, if anyone's going to get the death penalty, it's Nicholas Cruz.
Oh, yeah.
And so I feel like they walked in saying, if anybody's going to get the death penalty, it's Nicholas Cruz. And then they got beat. All right, I think we're getting the wrap.
Let's see what the voters say. That's going to be interesting how this plays out politically. Obviously impacts their gubernatorial race right now. It's going to affect their local elections right now. And there are people in Florida rightfully pretty upset.
Yeah, because the death penalty's on trial, not Nicholas Cruz. The death penalty itself. I think that's how they must feel. Final thoughts.
No, you
After
just
dark.
nailed it. You just nailed it. That is exactly what it is. I mean, these are always political. Sometimes people want to believe that the law is sort of above politics. It's not. It's underneath it.
Yeah.
A lot of the
It
people
is
involved are
politics.
elected officials too. It is
Is
politics.
politics. I agree.
100%.